lot of people will just take down answers. We'll just ask questions to get information from the other side so they can prepare their cross-exam for trial. Other people will try to be more aggressive. Just ask the questions to get ready for trial. Because every time you get a good thing in deposition, if you get good answers from them, they're going to have an explanation for that at trial. Because if you hit them with all your good stuff at a deposition, their lawyers take those depositions back to their office and they read through those depositions. And when it's getting ready for trial, they focus on those answers that they know are bad. It's always good to save it for trial so the jury can see it, the guy's real answer rather than the lawyer's answer, but it happens.
Welcome to the McKay Way Podcast. Today I have a very special guest, Jay Gray, who is a trial attorney. He has been a trial attorney for decades. He has tried cases all over the country, but primarily here in Texas. He went to Baylor Law School and he was second in his class, and I'll let Jay tell us a little bit more about his background. So, Jay, what can you tell us about your trial experience and your career as a lawyer?
Okay. Well, I started out at Baylor Law School, like you said. I got out in 1990. Baylor's a little bit different. It's the quarter system. So, I graduated February 90, took the bar, started working for a defense firm initially that represented like TU Electric, did mostly defense work. Well, that lasted about a year and a half. Then I went to work for a gentleman out in Tarrant County, Fort Worth, and we became Bergman Gray out there.
So you became partner?
I went to work with, it was Bergman, and then I became partners with him and became Bergman Gray. I stayed there probably about 10 years, tried a lot of cases. We had a good practice there. And I decided to leave there in probably after about 10 years, and started my own practice, Gray Law, and then I decided to come here to Dallas and join up with Andrew Bergman. So it's Bergman Gray.
So you have a practice now with Andrew Bergman. So it's Bergman Gray, yes. And you all handle what kind of cases?
We do a lot of commercial litigation. It's all we try. We take cases that are in litigation or going to be in litigation. Almost always on the plaintiff side. We've done a few random defense cases, but they were mostly for friends or something like that where we were helping them. But we almost always do plaintiff's work, and that's the person doing the suing, or the injured party is doing the suing. It's the plaintiff, and we any kind of case they'll go to trial. But I do a lot of personal injury. Done a lot of personal injury all my career. But I'll try other cases too. I do a lot of insurance bad faith, things of that nature, which isn't necessarily personal injury, but it can evolve into personal injury.
You've done medical malpractice, nursing home, trucking cases, catastrophic death cases,
all kinds of personal
products
injury cases.
liability.
I have. I've done just about any kind of personal injury case you could think of. I used to do a whole lot of nursing home cases. I used to do med mal cases. I developed a reputation for nursing home cases because we had a $250 million verdict, which was one of the largest, if not the largest still, contested jury verdict in the country. And I think it still stands as one of the, not the largest. But they changed a lot of the medical malpractice law a while back. And so we quit with tort reform. And so we quit doing as much med mal and nursing home cases. And now we do a lot of trucking cases, just regular car wrecks. But we also do a lot of commercial litigation.
And you've tried about how many cases would you say in your career?
At one time I used to keep count, because I remember back at one point you having to keep a count, but I would guess at this point it's total an estimate, probably between 300 and 400. It would be my
300 and 400 cases.
Yes.
That is very rare, especially for a civil trial attorney. Maybe in the criminal world, maybe, but definitely rare for civil, wouldn't you say?
I would say it's probably
top
1%, 5%, probably closer to 1% of lawyers that actually try that many cases. I mean, first off, trial lawyers are maybe 5% of the lawyers.
Right.
And they would have to have at least 20 cases before I would consider them a trial lawyer. Probably maybe 50 cases before I would even consider them a trial lawyer.
Really? Okay.
Yeah, but then after that, so then you get out of that group of litigation lawyers. Maybe 1% try that many cases. It's a high number.
So just trying one case does not make you a trial lawyer.
No, it doesn't. No, it doesn't. Trying one case might teach you how to become a trial lawyer. It's going to teach you. It's going to put you on a path. But trying one case does not make you a trial lawyer.
Okay, and speaking of a recent trial that I actually was able to attend, And you're from Texarkana, correct?
That's where I grew up, East Texas, Texarkana. Actually,
Texas.
Actually on the Arkansas side, but somewhat, it's right on the border.
It's right on the border,
Yeah,
right?
yeah.
Well, you had a case in federal court there, and you were against the owner of the Dallas Cowboys, Jerry Jones. Is that right?
That's correct. It was a fun case. When I say fun case, it was an unusual case. There was a lot of press around that, but yes, we did have a case that ended up trying in federal court there, and it resolved not quite midway through, but say toward the beginning of the case, it ended up resolving. But yes.
What I found interesting is Jerry was actually very nice to us, even though I was, rooting for your side, which was in opposition to him.
Despite, I don't really like doing this, but to be honest, I give him credit for that also because, I did the opening statement in there. I didn't get to cross-examine him because it resolved before that. I did take his deposition, and so I'd met him then. And during trial, during the opening statement, I was probably a little bit more aggressive than what I normally am, maybe even. Maybe I was very accusatory. I was very pointing my fingers at him and during the opening statement, and basically accusing him, telling him that I was going to come out, say certain evidence was going to come out during trial, and I was basically accusing him of being a bad person. And even after that, after it resolved, he was very amicable to me getting on the elevator. So I'll give him credit for that. I was kind of shocked, to be honest.
Are you allowed to talk about?
Even the judge ended up saying something to me at one point about, well, Mr. Gray, you've been pointing your finger at him and calling him names all day.
Oh my gosh. Are you allowed to talk about what it was like taking his deposition?
No, I'm not.
Okay. Was it in person?
It was in person.
Was it long? Can you say that? Can you say?
Oh, it was maybe 2 or 3 hours, probably 3 hours, something like that in nature. But when the case resolved, I ended up getting on the elevator at one point, going after the case was resolved, walking outside, and we happened to get on the elevator at the same time. Mr. Jones was very nice and very cordial to me, even despite all the things that I had said. And so, that shows some, I guess, character on his part, but also the fact that I was able to say those things in a way that I don't think made him so mad that he was chasing me out the elevator.
I had the opportunity of seeing part of that trial, and I did find it interesting that when we broke for lunch, it was actually right before I believed it resolved. I don't know, but he spoke with. I brought one of my children, and he got to meet them, and then I actually shook his hand, and he was very nice, and I was surprised at how cordial it was, off camera, so to speak.
Yeah. Were you there during opening?
I wasn't there during opening.
Okay. Yeah.
But yes, I did follow the news story because I was actually somewhere eating dinner, and it was on the TV that when the jury left the courtroom after his I guess the mother of the daughter was on the stand, she and Jerry embraced in the courtroom. And that made the news because the reporters were but it was outside the presence of, do you remember that?
It was there was a lot of strange things that happened during that trial. Yes, I do remember that.
Okay.
And so, yes, I do remember that. But that trial was very strange in many ways. But, it got to a point where it was kind of interesting. But yeah, it did resolve. But, I've had other cases where I have, where I was basically raking the people across. I've had a couple of truck drivers, a truck owner, company owner, starting to take me outside,
After their cross?
After their cross, yeah, they weren't happy. But, I try to normally be nice in my cross. I would say nice, I should say respectful. It's a respectful cross-examination. I try to be respectful.
So how can someone train for cross? Is that just experience, or is there, any kind of special recipe that you have that gets you prepared? Because you got to think on your feet, I would think.
I think you're either probably naturally good at it or not. I think that's I think you can prepare. I think you can learn things from other people, watching cross-examinations of other people do it, having a mentor kind of help you maybe a little bit when you start. I had a good mentor into the respect when I first started doing plaintiff's work to the effect that he was very good at cross-examination of doctors, and he very good with cross-examination of insurance adjusters, and so he taught me a lot from watching him do that I learned during those times, from how to cross-examine a doctor especially. He was very good at it, and I learned a lot from him to do that. But to be able to do it I think, and to do it effectively, I think it has to be your nature a little bit to be like that. I mean, you can watch and learn, and I think you'll be okay. I mean, I think you can you can look at the form books, you can look at the outlines, you can listen to other people, and I think you can take a lot of the questions and probably incorporate them and probably be okay. I don't think you're going to be great. I think unless it's your nature. Because, I mean, a lot of cross-examinations on your feet, because you got to listen to their answer when you're cross-examining. And so your next question is going to be a lot of times based on what they say. I mean, you can learn some basic questions to ask, but until you're until you're sitting across from them or they're up on the stand and you ask that question, you don't know for sure what they're going to say.
Right.
I mean, I've had too many examples of that. I mean, so all of a sudden we had one case. I'll give you an example. We had one case. It ended up being, it was a kind of I guess it's categorized as a landlord-tenant dispute, where a gentleman threw out his tenants a bunch of videos or master videos that were of shows, television shows, and the guy was renting from him. And we totally wrong what the guy did. And so we were suing him, and we started in court, and we had a mistrial. And then we had to have tried again. And I had taken the guy's deposition, the owner of the building, and he had given us one story the first time. And the second time during trial, he came up with a second story. And then the third time we were down there trying it, the third and final time, he came up with a third story that nobody had ever heard before. And he up on the stand of why he'd done it. And it was, it was totally unprepared. And totally unready for it. You wouldn't think somebody would switch their story and come up with something new the third time. So you just had to cross-exam based on his answer, a whole new cross-exam.
Right then and there.
Yeah, and I was able to show it was the third story he came up with, obviously. But being able to cross-examine him on this new story he just created all of a sudden that nobody, I don't even think his own attorney expected it, to be honest. He just came up with this third reason why he'd done this, and then so it was like off the cuff. You had to be ready. I mean,
can you share like the result of that trial?
Oh yeah, that's public record. They even tried to appeal. Yeah, we ended up getting a $3 million verdict on that.
Wow.
Right around $3 million verdict. And I think it was the highest landlord-tenant verdict that year. I know it was in Texas that year, and it's probably still one of the higher in Dallas County. That type of case.
So that happened here in Dallas?
It did. It did.
So I've heard that some trial lawyers would say, don't give away everything in a deposition. Other lawyers would say, you win a case in deposition. Some say, you don't want to share, or you don't want to almost do all your cross during deposition because you want to save those questions for trial. Do you know what I'm saying?
Yeah, I do know.
Can you re-ask the question?
Okay.
Because
Sure. Objection, vague, overbroad. Objecting to your question.
Okay, thank you.
No, Your Honor, that question was vague. No, I think I know what you're saying.
It was a compound question.
That's
the proper one, compound
It was
question.
compound, vague, ambiguous.
Yeah.
Let me back up a little bit. Are you talking about when you're taking, like, the defendant expert's deposition, or the defendant's deposition, or the opposing side's deposition?
Yes.
Okay. Not rather than your own client, obviously.
Yes,
Okay.
yes.
All right. So obviously I don't ever take my client's depo. But if I'm taking the other side, there's two schools of thought. The most prevalent is you don't throw all, there's two ways of doing it, I guess is the way to put it. A lot of people will just take down answers, will just ask questions to get information from the other side so they can prepare their cross-exam for trial. Mm-hmm. Other people will try to be more aggressive in deposition to, I guess, maybe to hope work towards settlement. Maybe I think it works more towards settlement. I do both, honestly. I've done both. It depends. If I think the case needs to settle because I'm worried about something, I will be more aggressive in the deposition of the defendant. Also, sometimes I can't help myself. You try so hard, but when they give a really bad answer, a dumb answer, you go, wait a minute. It's like that. I've had.
You got to call it out.
Yeah, you got to call it out.
Yeah.
All right, so sometimes you just can't help it. You can try to hold it in, it comes out anyway. But it is a good avenue to just ask the questions to get ready for trial. Because every time you get a good thing in deposition, if you get good answers from them, they're going to have an explanation for that at trial. Mm-hmm. Because if you hit them with all your good stuff at a deposition, their lawyers then take those depositions back to their office and they read through those depositions. And when it's getting ready for trial, they focus on those answers that they know are bad. And so they come up with some way to either see a hole in the question or to say, well, that's not what I meant. You didn't ask this, or the reason I said that was this. It always gives them an explanation. They always have time. And when you've got 3 or 4 good lawyers on the other side, high-paid lawyers, on the other side coming up with a reason, they're always going to come up with some reason to why the answer was the way it was. So it's always good to save it for trial so the jury can see it, the truth of the guy's real answer rather than the lawyer's answer. But it happens. But I'm a firm believer in you take a deposition. I think you kind of mix it. I kind of mix it a lot. Sometimes I will, I ask all the basic, easy questions, all the fluff questions so that you can get ready for cross. And then I also sometimes will ask kind of tough questions and be aggressive. Just kind of mix it. Kind of depends on the deponent too. I mean, the person you're taking their deposition, because sometimes if you get aggressive with them, you can get them to start admitting things. If you
so you've gone against like major companies, right?
Yeah. Let me give you an example of a deposition that I did against a doctor. We had a case where the doctor had left a sponge in
the patient.
In the patient after surgery. He'd gone back in a few days later and took it out. But
so the patient lived.
Yes, the patient lived. That medical record got buried. That lady that I was representing that he did it to was a radio tech. Well, I'm getting off topic a little bit. There's 2 different things. So anyway, it was a radio tech. Let me finish the story. It was a radio tech. She knew people at the hospital. Well, somebody pulled the record out for her because she had friends there. And they said, hey, this doctor came and said, we need to get rid of this record. And so, but they pulled it out and here's a copy of it. So she gave it to me. And she also had a follow-up meeting with the doctor. Now, she asked me about recording it. And of course, I said, at that time, there was some question as to whether a lawyer could advise a person to record or not. And I told her I couldn't advise her to record. I told her it was legal and it would be admissible in the proceeding because as long as one party knows the recording is taking place, one party to the conversation knows it's taking place, then it's not illegal in Texas. It's different in every state, but in Texas it's not. And so she went to her meeting with the doctor and recorded what he said in the meeting. Well, I get into it, and she gave me the tape. I had to transcribe. Well, after that, I go to take his deposition, and he lied about what he said in the follow-up visit. And so I pull out the tape and say, well, did you know you were being recorded? And he's, of course, no. And so I pull out the tape. There's a big dramatic pause. And they need a break to talk about it and all this stuff, and they take off, go outside the break room, come back. So finally he admits to me he said that. Okay. So now the recording was awful. You could hardly hear what was being said because I guess she had it in her purse or something, or her pocket. I don't know what it was, but you could hardly hear anything being said. You couldn't make out very little. Matter of fact, I think I asked him the one thing you could make out on the tape. But then after I asked him that question, I every time I would ask him a question and I didn't think he was telling the truth, I'd just act like I was reaching for the tape. And he would all of a sudden go, well, I may have said, I may have said that. And so it was just like, all I had to do was look and like I was reaching for the tape. And so, I didn't save that for trial because, I figured I could get the better answers out of him by bluffing the tape because I knew at some point I was going to have to give this tape up and they were going to find out we really couldn't hear anything on it. So I just kept bluffing, like every time I would reach in, I'd like, are you sure? And he would just agree with me.
So did that one settle?
Yeah. Yes.
So, Jay, who would you say, you've come across so many different trial lawyers and lawyers throughout your whole career. Who would you esteem as the 2 best trial lawyers of all time?
Easy. 2, David Perry and John Howie.
And what made them so great?
I saw both of them. They were both plaintiff's lawyers. And I'm kind of limiting this to plaintiff PI lawyers or civil lawyers. And from my perspective, I'd have to think about it for a while about defense lawyers.
On the plaintiff side.
But on the plaintiff side, David Perry and John Howie. John Howie was an incredible lawyer. I saw him in trial. I knew him. Matter of fact, I was partners with his son for a while. But I had seen John before that, John Howie, and he's now passed away. But he was incredible in the courtroom. Just his presence, it just demanded respect. His presence just was credibility right off the bat. And I watched him cross-examine people, and I watched him in trial. He was an incredible trial lawyer. David Perry, I had the pleasure of working as local counsel on a case with him the first time I got to see him in trial. And we had a case against General Motors. It was a seatbelt case, and I was local counsel in Tarrant County. And he ended up getting a $50 million verdict. Well, we did on it. He was the lead counsel. Of course, we were local counsel. And watching him in trial, I had the opportunity to watch him in trial. He reminded me a lot of John. Their styles were very similar. They were both kind of, I guess, men that just demanded kind of respect in the courtroom and kind of exumed credibility. They were just both excellent trial lawyers. They were both really good at what they did. And I was impressed with both of them. And I've still to this day, those two are the best I've ever seen.
What makes a great trial lawyer?
It's different. Both of those guys, David Perry and John Howie, were very similar in their styles, to be honest. A great trial lawyer can be all kinds. He can be all kinds of personalities. I've had success as a plaintiff's lawyer because I can't be like John Howie or I can't be like David Perry because they're different. They were both bigger guys and kind of, just exhumed a certain amount of credibility in the courtroom. I think my personality is, and I have to be different, and I've had to adapt to my personality as a trial lawyer, which I think most people do. It's just to be different, be credible. And
authentic.
Just to be authentic and credible. I grew up in East Texas. I went to high school at Arkansas High in Texarkana. I don't have the best vocabulary. I don't have the greatest education background. After that I went to university, of course, in the Baylor Law School, which was great. But my upbringing wasn't as smart as some people. I always tease people about, or I joke about, I've seen people that just talk over the jury. I don't have the ability to do that. Mm-hmm. Most of the jury that I'm talking to either has my level of vocabulary or they're going to have I'm going to be able to relate to them. Mm-hmm. And so I can't talk over their heads because I don't think I'm capable. But even if I could, it's not a good thing to do, obviously. Mm-hmm. But, to me, my success has been basically because I'm authentic. And I tell people, here's the things about the case, and here's what you need to look at, and here's what, they're going to say. And then you just got to build up credibility. Mm-hmm. And then, of course, establishing it, you toughen it. I think, like David and John were so credible, they couldn't, I don't think, really, they would have had a hard time being the smart aleck sometimes in cross-examining that I'm able to get away with because of who I am. Mm-hmm. And because of my personality. And so I can be a little bit more of a smart aleck and the jury doesn't hold it against me. They think it's entertaining. Right. And I can be a little bit more entertaining than perhaps.
At least keep their attention.
Yeah, well, yeah. I mean, like,
that's kind of important.
The jury's so boring sitting in a jury box 9 times out of 10. I've gone and watched other trials and it's hard for me to keep awake sometimes. It's just like, I don't see how they do it.
I was going to ask you about that. Like, what do you think about the use of technology now? Because now it's getting more and more technical. You have the IPVO, you have back in the day, PowerPoints, but you can obviously elevate that. Do you like, technology, or do you want to keep it simple?
No, I think technology is good. I don't have any problem with that. Depends on the case, obviously, but technology can be very good. I mean, I think it's been a great help, actually. Having exhibits, having photographs, and being able to blow those up right away. I think one of my greatest things, one of the things that helped me a lot, was when printers, those large, big printers first came out, mm-hmm. Where you could make exhibits on your own. I had mm-hmm. one of those built for me. So, it was hard. If you wanted to have an exhibit made, normally you'd have to send it out to Kinko's or some other place, and it would take a week, or you had to have it way in advance of trial. It was very hard to get done overnight at the time. And so one of the first things I did was get one of those big poster printers. And so that I could come home after every trial and blow up after every day after trial. I mean, I'd come to the office. And I would blow up testimony from that day and say, here's what they said yesterday. So that the jury could sit there and see that and read it. And wow. The next day when I would come back, say, well, this guy said this and here's what he said. And if they ever tried to argue that, then I'd have it in black and white right there, a big poster. Right. And so it was hard for them. A lot of attorneys will try to change what was said. Well, he didn't say that in testimony. What he said was this, and they'll try to convince the jury of that. And if you hear it enough times, sometimes it does work.
Right.
You say, hey, he didn't say black, he said white.
Right.
And that's not what he said in his testimony. He said white. He didn't say black, and over and over again. So the attorney tells them that enough. Sometimes the jury start thinking, well, maybe he did say white.
Right.
But when you've got a big poster blow up right there, from the technology you're using that says, oh, hey, he did say white. He did say black, not white. It just helps.
What do you think of PowerPoints?
PowerPoints help because it gives the jury, I've always been told, and I'm the same way, I'm a visual person, and I think juries, 90% of them are visual people. If they see something, they're going to remember it a lot better. They're going to see it. Now, you got to keep them entertained while you're showing those things up there. So when you put them up there, you put a PowerPoint presentation up there, and you can go through it, but you got to keep the jury's attention while you do it.
Right.
So you can't just throw up PowerPoints and expect the jury just to read them and understand them and not be bored. That's one thing I've always tried to do is keep the jury at least entertained so that they're paying attention.
It also sounds like you can keep it simple so that they know what the main message is. Because I witnessed a trial locally in Hopkins County, and they had these experts, a recon expert and another expert. I'm a personal injury attorney, and I couldn't even follow all the technical, aspects they were talking about. I looked over at the jury, and half of them seemed like they were completely, lost or asleep even.
You've got to keep things simple. You've got to keep things that people are interested in and understand. If you get a doctor up there and he starts going off on all these medical terms, and you got to go back, you got to walk him back.
That can get complicated, I bet.
It can get complicated and jumbled up and boring. And I hate to say this because probably hold it against me, but if any doctors see this, but 90% of doctors don't have. I think your father's a doctor.
Yes,
so
he is.
90%
retired. He's retired.
90% of doctors do not have a personality. They just don't have.
Unless they're a urologist, then they're the funny ones.
Then they have fun. Then they're fun. And orthopedics surgeons are, I always called them the jock of the doctors.
Right.
They usually have a little bit of a personality.
Yes.
But you get a neurosurgeon up there or something. Oh my gosh,
Right.
it's the most boring thing in the world. And a lot of neurologists are boring, and it's like, you got to figure out a way to wake the jury up. You got to figure out a way to get them to let them relate to the jury so the jury can understand it. And the good thing about me, that's the good thing about my background and my education, I guess, from growing up is, we didn't have any doctors or lawyers in the family. So when the doctor starts explaining that anatomy and all these different things, I have to if I can understand it, the jury can understand it. So, because, it's usually, I'm at the same level. So I don't know them. I may know a lot of medical terms now, but I know in general that if it wasn't something that I would have understood when I first started practicing law and doing cases, that the jury doesn't understand it. The jury doesn't know it probably. And so you got to break the doctor down. So I'm pretty good at getting a doctor to break it down to English.
It sounds like when you look at a case too, you're looking at it from the common sense perspective of a juror. Does this make common sense? Can a jury connect this injury with this impact?
Well, you got to be. This kind of goes back to what you were saying. Well, you got to be simple in your cases. You got to, it's got to be something that's not so complicated that the jury doesn't follow the chain of events or the causation chain. And so you've got to keep things simple, and you've got to keep things. If you try to make arguments that are too complex and take too long to get to, your causation chain will disappear in there. And so it kind of makes sense if you don't. When I first see a case, when I first take the case to get it ready for trial, if I don't understand it, then why would I expect anybody else to? Mm-hmm. So I've got to get it to the point where I can understand it, and then we can present our case.
Right. Yeah. So what are the most complicated cases to try, would you say? Is it medical malpractice? Is it a product's liability? What would you say are the most challenging cases?
There's a mix. Medical malpractice are challenging because there's a lot of medical terminology. There's a lot of medicine involved. There's a lot of anatomy involved that people don't understand, so you've got to be basic and teach the jury a lot of medicine for them to understand. And that's a lot to learn in a short period. It took me a while to learn some of what I know. And that was case after case after case. It wasn't just sitting in a jury box and listening to one case. It was researching it, finding out about the case, and then doing more than one and finding another one and doing doctor's depots and having them explain it. And so you kind of learn things that way. You can't expect a jury to sit in a box they're only hearing the answers to questions that are asked, and understand, a lot of the medicine. I've had cases, products liability cases, they're not that hard. They're not that difficult. Now, some insurance bad faith cases can get difficult because of the jury questions that the jury answers at the end.
Well, I think that's a concept lawyers don't always understand, but you seem to be kind of an expert when it comes to insurance bad faith.
I've done a lot of insurance bad faith in my career. Yeah, we kind of started out at the first firm I was at doing a lot of insurance bad faith. And so I've done a whole lot over the years. And, I've kind of got a different perspective on how I think it's supposed to be, how insurance companies are supposed to handle their insureds, where a lot of insurance companies treat their insureds adversarial. They shouldn't, and that's wrong. It's just not, it shouldn't be an adversarial process, but it always turns out to be, because these adjusters are trying to keep the dollar values down, and instead of trying to help their clients, they're trying to fight them to keep the dollars down, and they get jaded. I'm not going to sit here and say there's not insurance fraud and a lot of bad things that happen in the insurance industry, and so these insurance adjusters, I think, even if they're not jaded at first, I think they get in that field and they see some insurance fraud, so they all of a sudden start thinking everybody's an insurance fraud, and they start treating their own insureds when they have something happen to them and when they need them, they start treating their insureds like an insurance fraudster, and it's just not the way it should be. So I think that happens a lot, and I've got you'd be surprised how many times I've gone into depots, and I'll be sitting across taking the adjuster's deposition, and I'll go, "Well, did you do this for them?" They're like, "Well, no." I'm like, "Why not?" "Well, they're on the other side." I'm like, "No, they're not. You're supposed to be on their side.
Right.
What are you doing? You're supposed to be helping them. You're in good hands argument, the Allstate slogan.
Right.
Yeah, we used to have the argument, you're in good hands, until you file a claim, then whoops. Yeah.
Well, drop you.
Yeah, and so there's two sides to every insurance company. That's the adjusting side and the claim side, the sell side, where they're selling you the policy, and then there's the claim side when you make a claim. The claim sides, they tend to be very adversarial rather than being helpful, whereas the sell sides are always nice and trying to sell you the premiums and sell you the insurance policies and get the premiums. They're always very nice and helpful.
Right.
But the claim side are just awful.
Right.
And so, I just have an opinion that, they're supposed to be on your side and they're supposed to help you. And it's kind of staggering how many times I've walked into a depot and deposition, and the insurance adjuster was very adversarial towards his insured. It's just amazing. But they're not supposed to be. Yeah.
So, you've never marketed before. You've had a long-standing career. You've had hundreds and hundreds of trials. Do you think a proper trial lawyer is one in which their record speaks for itself and the clients come organically? And does marketing hurt your chances of being a trial lawyer?
Okay. Let me clarify that answer.
Okay.
Okay.
You're not going to hurt my feelings.
No, let me clarify the question.
And that's okay.
It's not exactly.
I won't hold it against you.
It's not exactly accurate.
Okay.
So there's some things you don't know about my background probably that. Now, the first firm I was at, and I necessarily am not saying the name on purpose. Just because I don't want to give a plug to no firm, somebody else. Is we did market. We were known as the non-marketing. How did you say it? Non-marketers marketing.
Okay.
We were pretty expert, and we became, I guess, good at not marketing, but marketing that we don't market.
Oh, cool.
In other words, we didn't market for cases, but we had our name. We marketed our name.
It was more branding.
It was more branding, and we would. For example, I'll give you a good example of this that we did. I was doing a lot of nursing home cases then, so and so I got cases against a lot of nursing homes, and so we decided I thought it'd be a good idea to take out an ad in the paper and this was back in newspapers were still a thing before it was all digital. Took out an ad in the paper saying we're investigating a case against ABC nursing home, and then say if you have any information about this nursing home or the care of residents, please call our number. Well, obviously you're going to get calls from people who think that their parents were mistreated at that nursing home. So we were marketing nursing home cases without marketing for nursing home cases.
Right.
Yeah, so we were doing marketing. We also marketed to other lawyers for referrals, which means that we marketed the larger cases and we to lawyers, and where we in the market for lawyers. Because a lot of lawyers back then would refer the cases, and they still do. If they got a big case in, a larger case in, and they didn't have the ability to handle that case or didn't have the experience to handle that case, and we became known as the firm where you would send your larger cases to, that we would handle them for you once you got them in, and we would work the cases. We handled larger cases at that point, and so they would refer our cases to us. So we did market with other lawyers, to other lawyers, and we did non-marketing marketing, as I always like to say. But now, since then, and since I left there, I believe that you kind of I haven't done marketing since then, because I've chosen not to.
Right. I mean, it's definitely a choice.
Yeah, it's definitely a choice, and it's nothing wrong with it. I've never had the need to, because we either get cases that were referred to us by former clients that put the word out, or from other lawyers. Still, we still get a lot of cases.
Do you think it hurts an attorney in a courtroom?
I think it hurts yes. I
would say so.
Here's my opinion.
Yeah.
Most of your attorneys who market, like say on TV, they've never stepped in a courtroom. And everybody knows that.
Well, not everybody.
Well,
the clients don't.
Everybody in the
lawyers,
everybody in the industry knows. All the other lawyers, all the insurance companies, they all know those lawyers have never tried a case.
Right.
And so they know that they can settle a case for cheaper. And they know those attorneys won't go to trial. So they know that rather than have to send the case to somebody who will, they would rather settle it for less, so they don't have to share the fee. So these insurance companies offer less to these people that they don't think will try the case, and they get a lot of them settled out that way. So and a lot of attorneys, I'm a little bit more old school, but we just don't. We kind of look and laugh at most of those attorneys that market on TV.
Right.
We just kind of laugh. I never will forget us when I first started. Not when I first started, but I've probably been out maybe 6-7 years. I went to a baseball game. We used to have season tickets at the Rangers, and I went to the opening day. And a friend of mine that was working for us now had previously worked for a volume PI advertiser, somebody that advertised on TV. And they were down at a different suite, and so we walked down there to say hello to his former boss, which I also knew. And so we were sitting there, we walked in, and it was a suite full of all these attorneys who advertised on TV, that names that you would hear, advertising, the advertisers. And we were sitting there, and I was sitting next to the one gentleman I knew, the former boss. And he leaned over to me finally, and he goes, "Oh my God, all these lawyers are in here talking like they could try a case. There's not a lawyer in here that could try his way with a paper bag." He goes, "At least I don't pretend to."
Right.
He goes, "I'm a business. This is a business for me."
It's a business, right?
He goes, "I don't pretend to." And he was right. It was like, I heard all these lawyers sitting around, and they were saying some of the stupidest shit. Some of the stupidest stuff. It was like, really? You really think you could try a case? And I remember him turning to me and just leaning over and going, "Oh, this is ridiculous." And and that's the way most lawyers think of the ones that advertise. They're the TV advertisers.
Well, I do know, just knowing you and how you approach cases, a true trial lawyer actually wants to see the scene, wants to see what, where it happened. They want to actually meet with the client and see, how they're going to be in person. And when you get to, a certain, volume attorney, a settling attorney, they don't have a need to, because they don't, need that personal connection. But tell me, why that's so key.
Because they're not going to try the case. They take
why
it in
is
to
it
settle
important?
it.
Yeah,
it's very important. I mean, I don't take a case. I've never walked into. At least I'll say I haven't. At least I can remember walked into a courtroom where I didn't see the accident scene before I walked in. I mean, it's just like it's one of the first things I'm going to do is I got to go look at the accident scene. I got to get a visual of what happened. I mean, there's so many things that you can't get out of a police report. And trust me, so many times I've seen police reports where they're wrong. And it's just never, you can't rely on a police report. You can't rely upon pictures. I'll give you an example. Mm-hmm. We just went to Tampa. We have a case in Tampa where a gentleman was killed on a scooter. A truck was pulling out of a bar, a restaurant bar. It was pulling out onto the main road. And our guy was on a scooter on the sidewalk and they collided, killed the young man. It's a terrible, tragic accident. But, we had seen pictures. I mean, you pull up on Google, you can pull up the map, the satellite view or the map view or the street view on the Google and see what it looks like. Of course, those are, a couple of years long sometimes. But we actually, first thing we did was fly down there to see the scene. And we went down there. So you
literally flew to Tampa. You didn't just rely on Google Earth.
Right. No, I'm not going to just rely on that because we had photographs too. And they just did. So we flew down there and we, look at the scene. We go out there at the same time of night when it happened. And it's just a total different experience.
Wow.
Than what I thought it was. I thought it was kind of a dark area. I thought we found out the lights were real bright. It was a bright intersection. It wasn't at all. It was kind of a U-shaped driveway. But it turned out to be totally different than what I thought. And the club and restaurant was totally different than what I thought. We also found a camera that was pointed straight at the accident site, which we're trying to get the video from, because now that we have a video of it, which the owner of the club happened to be the truck that was leaving, also happened to own the restaurant. So he had told the police that there was only a camera pointed in the back and on the side. And we're like, well, we've got a picture of a camera right here pointed toward the front. Why don't we have that evidence? So now they're trying to get that tape. But until you actually go to an accident site, you just don't get a feel.
But do you realize how rare that is now? That most lawyers aren't doing the work you're talking about, or they'll send someone.
They'll send someone. All right,
that's like the most they'll do. But usually it's Google Earth, Zoom depositions, talk over the phone, sign a client up over the phone. How do you handle, this day and age, but still approaching things from, how you were taught? And why is that important?
I don't know if I was taught that way as much as I just always kind of found out I needed to do that. I don't know. It's like earlier I was saying I'm a visual person. So to me, it's like I don't understand something until I see it, until I go out there and see the layout, until I see what's happening, until I see the people involved, see where they were coming from, see what's right down the street, see where they were going. I mean, it's like you got to take the path they were going to take and find out. I mean, it's just you don't know until you actually. There's all kinds of things you discover when you do that. Now, we obviously take fewer cases than when I first started. I handle fewer cases now because we're a little bit more selective. So I'm able to spend more time with each one and do those things. Mm-hmm. But I'm not ever going to go to trial without going to the accident scene and see what it looks like. I've been a believer and maybe a little bit of a control freak, that I want to go do these things myself and discover these things myself. Even with regards to depositions, if I wasn't there taking the deposition, it's hard for me to read the deposition, get a feel. I like to be involved in it, so that I know, what a person is going to be like. A good example of that, a lot of defense firms will have their associates work a case up. Mm-hmm. Then the partner steps in the last minute and tries the case. He's never seen the case until the weekend before trial. I think that can be a detriment, because a lot of times when that happens, for example, there's one case where I'd had against a major construction company. I was representing a gentleman who was an illegal alien that had been paralyzed from the waist down as a result. But his supervisor, we took his deposition. Very incredible, very bad witness. Matter of fact, the first break that we took during his deposition, I was taking the court reporter who was taking down the testimony, the videographer, were making bets whether he'd even show back up. They thought he was going to disappear because it was gone so bad for him. Well, we get to trial, and he did show back up surprisingly, but it didn't go much better for him. But we get to trial, and all of a sudden this defense lawyer, who's really not done a lot on the case, starts talking about how their case hinges on the testimony of that witness. And I'm just sitting there thinking, oh my God, you did not see this gentleman at deposition.
Wow.
you're gonna rely on this to be your testimony. And sure enough, when the guy showed up, it went downhill. I mean, that witness, we got a $8 million verdict on the case, where I think they ended up finally offering $2 million or something like that. And it did not go well for them. So, and it was kind of funny.
So speaking of defense attorneys, you said before, some high paid attorneys. Does that necessarily mean they're better?
No.
Because you've gone against, the biggest firms, attorneys representing the biggest companies, and, it doesn't always mean that they're the hardest to go against, right?
No, not at all. Some of your smaller defense lawyers are better trial lawyers. than some of your big firm lawyers.
Okay.
Yeah, as a general rule, I would say that's true. Some of the good trial lawyers that I've seen they were from smaller firms. Yeah, and some of the terrible ones I've seen have been from the big firms. But that's kind of the nature of the beast. The big firms don't get to trial that often. Right. Because they're trying to protect their interest. It's a different beast. I learned that when I was doing defense work. As the big firms, it doesn't benefit them to go to trial. Now, it may benefit them to go up to trial, to build the case and work the case. But when they go to trial, they're at that point, it's just a risk. Because if they win, you should have won. You've been telling us all the way up to here, we're going to win. If they lose, then they lose a client. Mm-hmm. And then they might lose their partnership. And then, it's just a risk for those big firms to go to trial. Whereas, the smaller firms, they go to trial more often. Yeah.
Well, and you also mentioned, your previous death case. When you were, when you're handling death cases at trial, how do you handle the damages portion? Is that more complicated when you're dealing with, a death case and you're asking a verdict, based on pain and suffering, or
It is. It is. And the courts limit you now. There's been some limits on what you can do to try to explain damages. But I still think, and I'm not sure I even disagree with the analysis the courts have done on that or recategorization of that lately. I was looking at you kind of funny because I was trying to remember what death case I mentioned, which one you were talking about. And I know I've had.
Well, you said somebody who had died. Oh, the guy in the scooter that you.
Oh, the recent.
Yeah,
case
the recent
Tampa.
one.
Okay.
Yes.
I thought you meant when I tried.
Oh, I'm sorry. No. So when you were talking about and you've handled many death cases.
Yeah. That's why I was trying to remember which one you're talking about.
Yeah.
But the Tampa case is new. It hasn't even been filed yet. That's a recent thing. Mm-hmm. But we're investigating that now. So death cases, yes, death cases are different. But at the same time, they're not. I mean, it's like at the same time, people understand the death, what they cause. I mean, I guess what you're looking for is you're trying to be a little bit comparative to if somebody's injured in a car wreck and they suffer and they're still alive and they're still going through medical treatment, you can show how this person has been injured. They've been to the doctor. They're going to have to continue to go to the doctor the rest of their life. They're going to have this surgery, which changes them forever. Mm-hmm. And so their or back's never going to be the same like it was. God made it a certain way. Doctors can only fix it to a certain point, kind of argument. And that's true. And so you can say, well, this person's only 30 years old. They would have worked until they were 65, or their life expectancy is 75 now. So this is how many years they have to live with this neck injury, this surgery, and it's just gotten worse and worse, and it's going to get worse and worse as you get older. Nothing gets better as you get older. It always gets worse and weaker. So anything that's happening now, any pain they're having now is going to continue to grow worse and increase. Whereas in a death case, the person their pain and suffering is ended, but their loved ones hasn't. So that loved one still is going to have to live the rest of their life with that nightmare. It can be difficult, but I had a client one time, and I use this in a lot of my cases to explain how to consider the anguish that a mother or father might suffer as a result of their son or daughter dying, being killed. I had a client one time, and we had him up on the stand, and his daughter had been killed in a playground accident. And I remember him. He said that his testimony was, and I didn't expect this. This was kind of when I was still kind of a young lawyer. Maybe I'd been out 8 years or so. Every morning when he first wakes up, he doesn't realize that she's dead. Every morning he wakes up, and for the first 5 seconds, he thinks of her and that she's still alive and in the next room. And it takes him 5 seconds, at least, for his mind to register back that person is not there and why they're not there. And I tell you, when he did that, I was crying.
It's hard for me not to cry.
I mean, when he said that, I was like, yeah, and that's what happens. And, and I've asked my clients after that, after hearing that testimony, it's like, is that true? Does that happen? And they say, yeah, every day. And so I've always explained that to the jury. You know, if that person is 40 years old and they've lost a daughter and they're going to live to be 75, you know, that's 35 years of every day waking up and re-going through that whole experience again every day. Because you can't make your mind. You don't make your mind realize that person is not there until you have to do it consciously. So he would have to remember every day, and this is true with everybody I've spoken with since, that person is not there. So they have to make that conscious, they have to remember that every day for the rest of their life while they're conscious. What's that worth? I mean, what is it worth? I can't imagine. I don't know what it's worth. You know, and there's no amount of money that I would go through that for. And so I've had good luck explaining that to the juries and saying, you know, this is what they have to do every day. They have to make that conscious decision and remember and live through this event every day the rest of their life. And that's because of the defendant's fault. I mean, this trucking company that killed your daughter or killed their daughter or something. And that's usually, you know, the best way to explain it.
And that, ladies and gentlemen, is why Jay Gray is one of the best trial lawyers in the country, because that I think that will be a takeaway. So many attorneys will that do try cases will remember, because what you just explained is so impactful. It really does explain in such a way that's so hard to explain.
Yeah. Honestly, I have a hard time making that argument, keeping dry eyes half the time, because that makes me remember what they have to live through and so suffer. But yeah, that's just something you learn. And I learned it from him.
Yeah, I guess you do learn most from the clients that actually go through it. So thank you, Jay Gray from Bergman Gray Law Firm here in Dallas, handling cases all over the United States. And thank you all for watching the McKay Way podcast with our guest today, Jay Gray. It happens to rhyme. Again, he is with the Bergman Gray Law Firm. They do all civil litigation, trial lawyers, catastrophic personal injury. And if you want more information, please subscribe, share, and we will see you on the next episode.
Thank you for having me today.
Yes, thank you.
I enjoyed talking.
Thank you so much.
Yep.